Leave to remove essentially is permission to take a child to live in a different country. And so we talk about leave to remove, where we're looking at an application to the court for the court to give permission or grant permission or not for a child to move with a parent to live in a different jurisdiction. Now, that only becomes an issue if the parents together can't agree that a child can move with one of the parents to a different country. So a lot of cases we don't even see, because the parents will have reached an agreement that perhaps, I don't know, the mother has got a job in a different jurisdiction and wants to be able to take that job and move with the child over there for a period of time. And the father says, okay, well, I'll agree to that as long as I can come out, to Paris, say, I can work from home on a Thursday and Monday and Tuesday, and I get more of the school holidays for that period of time. So they may end up being able to reach an agreement between them. They may have gone to mediation and had some discussions alternative to a court dispute. But essentially, where there can't be an agreement reached, then the court, there's an application to court, and the court have to consider and grant leave or permission to the parent who wants to leave with the child to take that child to live in a different country. For children, their parents are the most important people in their lives, usually. And so children have a right, and it is a right, to have a relationship and spend time or live with or share arrangements with both parents. That's their right. And in the context of a leave to remove application, it's really important to consider how each parent will play a role in their child's life. If that parent is going to be limited in the time they can spend with the child because they're living in a different country. And obviously that's very difficult, and that needs to be really carefully thought through. And what particularly needs to be thought through is if there is to be consideration for a relocation in any way, even if it's a different part of the country, how is that going to work for the parent who's going to remain living in the place where the child has essentially been removed from or relocated from? And at the forefront is going to be, well, what's going to be best for the child? How is that going to work? What time are they going to spend together? How are they going to maintain their time together? So, the court will be very keen and very concerned to ensure that a child is still maintaining a good relationship with both parents, however that may be and however that may work. So when looking at whether to make an application to leave the country with your child to a different jurisdiction, you've got to have really thought this through. This can't just be done on a whim. This has to be a very carefully planned and thought through application. And what the court will want to know is, how is all this going to work? How is this going to work for the child? And what's the real reason behind it? And they'll see through the reason being, well, I just want to get away from the other parent and move as far away as possible. That's just not going to work. This is going to be about, perhaps a move for, say, a mother to the country where she's from, where she's got family support, where she's going to have her family or parents in the next village, where she's got a more affordable level of housing, where there is a good school where the child can attend, or, for example, in a case where the child is preschool, is there a nursery? Is there a nursery in the area? Is it good? What hours would they take the children? And all of these things. Has the parent got support? Is there good support locally? Is there good social amenities for the child? Are they going to be able to make friends, etc.? But most importantly, how are they going to maintain a relationship with the parent that's left behind? There needs to be a really carefully thought through plan. If this is going to hold any weight, if the court is going to seriously consider this needs to be done properly. Your statement in support of any application for leave to remove is your key piece of evidence. That's really, really important. It's very difficult for a parent who is essentially going to be the parent that's going to be left behind if any application by the other parent succeeds and the children are going to relocate to a different part of the UK or to a different country, because of course they're going to be looking at the fact that the arrangements they've got in place currently for the children are going to change, and their view may well be that it's going to be a change not for the better for the children, and it's going to actually not be in the children's interests for this application to be granted by the court. So they're going to be focusing on essentially defending such an application, and their reasoning may well include the fact that the children are settled, that there's a routine currently in place. Status quo is that perhaps the children spend regular or even half of the time with each parent, and so their view is that the time they spend with the children is going to be severely curtailed, which won't be in the children's best interests, and they won't be able to equally parent the child or children because they won't physically be able to do so, and their concern will be that that will be of harm to the children, and such that, therefore the application shouldn't succeed. They might be concerned about their education, they might be concerned about their lack of friends. What about their family support? They may regularly spend time with aunts, uncles, grandparents, etc., which a move to a different country will not allow in the same way. So they're going to have a lot of considerations as to why they don't feel that such an application should be granted, and they're going to need to set that up very clearly in their evidence.